Hello, hello, there we are. Welcome to Trial TV Live. I am the Squeegee of Justice. Thank you so much for joining us today. Let me just check my audio here. Thank you guys for coming in. I was muted there for a moment. Just give it a second. Hello, hello, there we are. All right, cool. So thanks for joining us. This is Jose Soto-Escalera's sentencing. They went through the Spencer hearing last week, and now actually it was on Monday, a couple days ago. And now here we are to hear the judge's final decision. So welcome in, everybody. Welcome in. Richard, how are you? Mallory, good to see you. Edwadi, good morning to you. Mike Morrow, good to see you. Alice and Sharon, Sparkling Princess, good to see you. Good to see you. Hellrider, good to see you. Give me a microphone. Check, check. Check. The check's in the mail. Sibilance. Sharon, good to see you. Mary, thank you for joining us. And Pammy, Nan R. Northwest, hi to all the cool kids. Alice, Brett, good to see you. All right, Sparkling Princess, double stream, yes. And Sherry, you made it. All right. I got to pay attention over here too. Hey, Terry, good to see you. All right. So we actually have a feed. Let's get to our feed. All right, here comes Jose. No audio yet. Hey, Linda, thank you for joining us. Michelle, good to see you. Jose's sentencing. Let's see what they're going to do. All right, I hear some audio. Hey, Kathy, Marinthia, how are you? Rich Auntie, hello, hello. Oh, and he's gone. Alexis, hello, hello. Thank you for joining us. All right. Poll for DP or life. Let's see if I can get one up fast enough. Which is the judge? What is the judge going to do? All right. Good one, Hellrider. Let me get one up. Hello, Super Ball. Super Ball's cruising by. Oh. All right. All right, new poll for you guys. New poll for you, chat. Hey, MJ, thank you for joining us. You guys see Super Ball? She's hanging out over here. She's right there. Super Ball's hanging. God, they're doing that too? Serious? They're going to just be obnoxious and do that. All right, well, we can do this. All right. All right. Hey, Nanar, good to see you. Petunia. Amy, good to see you. Haven't seen you guys in a while. All right, we are dual streaming, so I have to pay attention to a few things. Let's see, I gotta go this way. You can see Super Ball. See Super Ball over here? Super Ball's right there. Wink. There she is. Her little head. Super Ball's head. Little Super Ball. All right, so this is going to put Jose Soto-Escalera to bed one way or the other. What's it going to be? Hey, Tim, hello to you. Christine, thank you for joining us. So they're scheduled to go at the bottom of the hour. Sparkling Princess says hello to you. She's being indifferent right now. She's being indifferent. Hey, Queen Olive. Thank you for joining us. She's got her back to us, Super Ball. Mary Fitz is back. Good, good. Thank you for joining us. So they came in, they brought him in, and hey, Kimbers. Just got back from a unsuccessful trip to the courthouse. Funny, longish story. All right. Hey, if you still want to call in later, that's cool. We're gonna do Bianca after we're finished with Daisy. So let me know. Got my hands full right now with 2 streams, but once this is over, we can talk. Ooh, ouch! That doesn't sound good. That was not fun, right? Hey, Barry. Good to see you. 3 trials in one day. Yep. We're doing 3 trials in one day. Yeah, Kimbers, we're not going to get to Bianca until after we're finished with Daisy. This will probably be 10 minutes, right? 15 minutes. And then we're going to do Daisy. We're going to continue with Daisy. And then we won't get to Bianca until like 5, even 6 o'clock. So you have plenty of time. I have plenty of time. But I'm glad that you went to the courthouse. I mean, at least you tried. So that's cool. At least you tried. Valerie, thank you. This has become my all-time favorite channel. Oh, awesome. Awesome. Thank you. Nice to have you on board. So happy that you guys are with us. All right, I'm going to pop over here real quick. I'm going to leave this. This is active, so I'm just going to pop over to the... Oh, here we go.
Be seated.
All right, all parties are present. I'm going to read the sentence of the court into the record at this time. In doing so, there are portions of the sentencing order that are case law citations that I will not be reading, but they do appear in the written order. Police found the body of 23-year-old Tania Wise face down in a culvert ditch on the side of the road in a remote rural area of St. Lucie County. She suffered a significant blunt trauma blow to her skull, fracturing it and causing internal injury to her brain. Her throat had been cut. There were 2 deep lacerations on her neck, going right down to the bone. One from the midpoint of her throat to just under her right ear, and the other from the middle of her throat to her collarbone. The medical examiner could not specify the sequence of the injuries. Therefore, the degree to which Tania experienced terror from this horrific murder could not be proven. The blow to her head was so devastating that if it was the first blow, it would likely have rendered her unconscious and in and of itself could have caused death. The slashing of her throat was so violent, deep, and penetrating that it, in and of itself, was a fatal injury. There were no defensive wounds found on her body. Tania was in the very late stages of pregnancy of a baby boy whom she was going to name Josiah. DNA analysis proved the defendant to be the boy's father. As a result of her murder, the baby also passed. The defendant, a man in his 40s, plotted and planned her murder for days. His days of planning and plotting were caught on audio and video. Please silence your phones. He drove a garbage truck for a living. The trucking company had installed recording devices in all of its trucks for liability purposes. His working companion on the truck was his nephew, Eric Alvarado. As reflected on the recordings, he told his nephew that Tania Wise was going to destroy his life by exposing their illicit affair and the resulting pregnancy to the defendant's wife. Well in advance of her murder, he chose a location to kill her and dispose of her body. The location was along the street path of his garbage truck work route. After the murder, he recounted the events to his nephew, telling him how he covered it up. In planning the murder and recounting it, he did so in a remarkably callous, carefree, and nonchalant way. When police later interviewed him, he feigned surprise to hear of her murder. He claimed he only knew Tania as an acquaintance and never had sex with her. He completely denied the possibility that the baby boy was his child. The jury convicted the defendant of the first-degree murder of Tania Wise and the first-degree murder of her unborn child, Josiah. Unanimously, the jury made a written finding of the existence of the following statutory aggravating factors. 1. As to both victims, pursuant to Section 921.1416B, that the defendant was previously or contemporaneously convicted of another capital felony or of a felony involving the use or threat of violence to the person, which, respective to each count, is based on the contemporaneous conviction as to the victim involved in the other count. 2. As to both victims, Section 921.1416I, that the capital felony was a homicide and was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. 3. As to the unborn child, Section 921.1416L, that the victim of the capital felony was a person less than 12 years of age. By a vote of 8-4, the jury recommended a sentence of death as to the murder of Tania Wise. Also, by a vote of 8-4, the jury recommended a sentence of death as to the murder of Tania Wise's unborn child, Josiah. After receiving the jury's recommendation, the court allowed the defendant a separate hearing to allow for an opportunity to argue and present additional mitigating evidence pursuant to Spencer v. State. Weighing of aggravating factors as to the murder of Tania Wise. Pursuant to Section 921.141(6)(b), the defendant was previously convicted of another capital felony for threat of violence to the person, which, respective to each count, is based on the contemporaneous conviction as to the victim involved in the other count. This aggravating factor was established as a matter of law as to each victim by virtue of the jury's convictions for 2 capital murders. Violent felonies committed contemporaneously with a capital crime can qualify under the prior violent felony aggravator, where, as here, the criminal episode involved multiple victims. The prior violent felony conviction aggravator is one of the most weighty in Florida's sentencing scheme. The court assesses its weight as to Tania Wise as follows. To understand how weighty this aggravating factor is in this case, it is noteworthy that this aggravating factor could be satisfied if the defendant had premeditated the murder of one person, but simultaneously and spontaneously committed a violent felony upon another person, such as an aggravated assault or aggravated battery. But here, there are 2 simultaneous premeditated murders. This is the much more extreme scenario in which this aggravator can be established. Therefore, it is entitled to very great weight. The court affords it very great weight as to Tania Wise. Pursuant to Section 921.1416I, the capital felony was a homicide and was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. The cold, calculated, and premeditated aggravating factor focuses on whether the defendant had a careful plan or prearranged design to commit murder before the fatal incident. Calm reflection is often involved. The evidence of calm, cool reflection and planning well beyond what is required for premeditated murder is overwhelming in this case, and the court finds it proven beyond a reasonable doubt. To maximize the chances of avoiding detection, the defendant coldly contemplated in advance every aspect of these murders, including the location and method of killing. He did so in a remarkably callous, carefree, and nonchalant way. As to Tania Wise, the aggravating factor is entitled to very great weight. Weighing of aggravating factors as to the murder of the unborn child of Tania Wise. Pursuant to Section 921.1416B, the defendant was previously convicted of another capital felony or of a felony involving the use or threat of violence to the person, which, respective to each count, is based on the contemporaneous conviction as to the victim involved in the other count. As to the unborn child, the court's analysis of the weight of this aggravating factor is the same as to the murder of Tania Wise. The court affords it very great weight as to the unborn child. Section 921.1416I, the capital felony was a homicide and was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. As to the unborn child, the court's analysis of the weight of this aggravating factor is the same as it relates to the murder of Tania Wise. As to the unborn child, the aggravating factor is entitled to very great weight. Section 921.1416L, the victim of the capital felony was a person less than 12 years of age. The court finds this factor proven beyond a reasonable doubt. The child in this case was unborn, yet fully formed and about to be born within days. The premeditated murder of this baby deprived him of ever experiencing life outside of the womb. The premeditated murder of an unborn, fully formed human being still in the mother's womb, about to be born within days, is by its nature extremely abhorrent, reprehensible, and strikingly revealing of a malevolent mind. The court affords this aggravating factor very great weight. Findings regarding mitigating factors reasonably established in ways to properly carry out its important duty and to allow for meaningful appellate review, this court must expressly evaluate herein each statutory and non-statutory mitigating circumstance. In addition to the mitigation presented to the jury, the court has also considered any suggested mitigation from the Spencer hearing. Any proposed mitigation, whether statutory or non-statutory, must be reasonably established by the greater weight of the evidence. If a statutorily listed mitigating circumstance is supported by the evidence, it must then be weighed as to its significance. Unlike statutory mitigation, the court must first determine if proven non-statutory suggested mitigating circumstances are truly mitigating in nature. Once truly mitigating non-statutory mitigation is established by the greater weight of the evidence, the court must weigh it. It is within the sentencing judge's discretion to determine the relative weight given to each established mitigator. Because of the overlapping and related nature of many of the mitigators, the court has grouped some of them to ease and clarify the analysis. The court has still individually contemplated and considered the nuances of each of the suggestions in weighing them. The court has carefully applied its reasoned judgment in this regard. Statutory mitigating factors. Considered statutorily listed mitigating factor. The defendant has no significant history of prior criminal activity, and considered related non-statutory mitigating factor, the defendant has no prior history of violence. These circumstances were established by stipulation as to no prior criminal history in general, and by testimony as to the lack of violent history. This included specific instances when the defendant maintained his cool when others might have reacted more aggressively. Adding to this mitigation is that during the defendant's life, he was faced with stressful circumstances similar to those posed by the threat of exposing his infidelity in this case. Specifically, he was on more than one occasion taxed with his self-created predicament of supporting children he fathered out of wedlock. On those occasions, he did not respond with violence or criminal activity. Rather, he responded responsibly. Additionally, during the breakup of his relationship with Madeline Cologne, she put him in a situation where many men might respond aggressively, but he did not. When she discovered his involvement with another woman, she burned his clothes, broke his phone, keyed his truck, and flattened its tires. Despite this, he remained calm and did not act violently. According to her, he handled it perfectly. Childhood reports of the defendant's behavior were consistent with him being non-aggressive. Family members reported that they had to stick up to bullies on the defendant's behalf. This mitigator was established, and it is entitled to moderate to great weight. Non-statutory mitigating factors. Considered related non-statutory mitigating factors. While in jail custody awaiting trial, the defendant has been a peaceful, mostly compliant inmate. The defendant can positively contribute to society as an inmate worker if sentenced to life in prison without parole. The defendant has demonstrated exemplary jail-prison behavior. The defendant will be required to work 60 hours per week in general population at the Florida Department of Corrections if sentenced to life without the possibility of parole, and he would adjust well in that general population setting. He would likely contribute to the prison system. The defendant poses no danger to prison, jail staff, or inmates. The defendant will be completely incapacitated and pose no danger to the community with a sentence of life without the possibility of parole. As listed by the defense, the defendant, quote, can be redeemed, unquote, which the court takes to mean that he would prove to be a good inmate. Since his arrest in 2018 for these murders, while in the county jail, the defendant has only committed 3 disciplinary violations, and they were all minor and virtually insignificant in nature. He's had no fights with other inmates or violent encounters with guards. The testimony did credibly establish a significant probability that the defendant would be a model prisoner if placed in general population. The defendant's personality and work skill set would suit him well in general population. The court finds these mitigators to be proven and affords them moderate weight. Considered non-statutory mitigating factor. During a previous romantic relationship with Lucinda Cook, the defendant acted like a gentleman and was nonviolent in the face of instigating behavior by Ms. Cook. Ms. Cook was a gas station attendant and the mother of 3 young children when she started dating the defendant approximately 10 years before the murders. They dated for a year and then lived together for a short time. When she met the defendant, she had just come out of an abusive relationship and as a result was impatient and verbally abusive to the defendant. There came a time when she decided to end her relationship with the defendant for reasons unknown to the court. During the term of their relationship, she described the defendant as acting gentlemanly to her and her children. Her children were fond of him. The defendant made her and her children feel safe. According to her, despite his model gentlemanly behavior, she found fault with everything he did and argued with him for essentially no reason. She described that during their time together, it was common for other women with whom he was also romantically involved to come around her and cause problems. She went out of her way to emphasize that this was no fault of the defendant. When she decided it was time for him to leave their relationship and presumably their domicile, she pushed and damaged his fancy motorcycle and spat in his face. Despite her aggravating behavior, he never argued, got mad, or did anything to retaliate. She never saw him act violently, even though he was apparently employed at that time as a club bouncer. To the contrary, rather than describe him as violent or ill-tempered, she described him as behaving, quote, like a clown, unquote. She never saw him angry enough, quote, to do something, unquote. She described him as exemplary and that in hindsight she should have treated him better. On cross-examination, she conceded that since the time of their separation she avoided all contact with him. However, recently his family persisted in making phone calls to her in an effort to make her come forward as a character witness for him. Her first contact with the defendant after their separation was approximately a month prior to trial. The court's conclusion regarding this witness and what her testimony establishes is as follows. Her overall credibility is low. The court believes she exaggerated the truth. However, there is enough truth in her testimony such that she established this mitigating factor. The weight of the mitigating factor is reflective of the source that established it, her testimony. Therefore, the court affords it moderate weight. Considered non-statutory mitigating factor. The defendant was abandoned by his father as a child. At trial, there was scant evidence of this other than a mention that the defendant, quote, never really spoke to his dad, unquote, by Miss Cologne. There was also testimony from Joanne Stone that the defendant's father was a bus driver and apparently lived with him in Bridgeport, Connecticut. However, the Spencer hearing evidence established that the defendant's father moved out and played an insignificant role in raising him. Therefore, the court finds this mitigator to be proven and affords it little weight. Considered related non-statutory mitigating factors. The defendant was raised in chronic poverty. The defendant left school early and lacked the opportunity to complete his education. The defendant was resilient and overcame his lack of education through consistent work ethic. The defendant began working and earning money to help support his family at a young age. The evidence established that the defendant was raised in a low-income environment and likely had less opportunity to further himself than most other people. However, as testified by Monica Ropeza, his cousin, they were low income, but, quote, had what they needed, unquote. These circumstances were proven. The court affords them little weight. Considered related non-statutory mitigating factors. The defendant suffers from transgenerational family trauma. The defendant experienced chronic exposure to trauma during his childhood. The defendant's mother had a traumatic upbringing because she was abandoned by her father, causing her to leave school. When she was only 15 years old, she got pregnant with a son who died in her arms from illness about a year after birth. Naturally, the death of her son was traumatic for her. The defendant's father was older than she, making their relationship illegal. After the death of her first son, at 17 years of age, she became pregnant with the defendant. The defendant was raised in a low-income, crime-ridden neighborhood. Early into his life, his parents separated from each other. His father was largely absent, but did live nearby. At some point during his youth, the defendant's mother developed a drinking problem. This caused her, to some degree, as a single mother, to be emotionally or physically unavailable to him. The defendant did have a large extended family immediately available to him. Some of them were drinkers too. His aunts, who lived in his public housing project, to some degree helped raise him. There was broad, general, non-convincing testimony that the family was exposed to, quote, drug dealers, fights, and crazy people, unquote. The court finds these mitigators proven and assigns them little weight. Considered non-statutory mitigating factors. The defendant has established and maintains long-term, substantive, meaningful relationship with friends. The defendant has established and maintains close family bonds, relationships with his cousins. The defendant has maintained a close relationship with his mother. These were established by the evidence. The court considers this mitigation also in the greater context that the murders in this case, as aggravated as they are seemingly out of character. The defendant's life relationships are not typical of the type of antisocial person one would expect would commit the murders in question. The court finds these mitigators proven and affords them moderate weight. Considered related non-statutory mitigating factors. The defendant has established and maintains close family bonds, relationships with his children. The defendant provided support for his children. The defendant has established and maintains or maintained before his incarceration close family bonds, relationships with the mothers of his children. Aside from committing the murders, the defendant has been a positive influence on family members. The court finds these mitigators proven. There is a huge contradiction between how the defendant responded to the prospect of fathering his child to be born of Tania Wise and how he supported his other children. The defendant supported his other children generously according to his means and without compulsion. He was very active in their lives. With regard to one of his children, his support continued even when he learned after years of support that the child was not in fact biologically his. The court affords these mitigating factors moderate to great weight. Considered related non-statutory mitigating factors. The defendant was a positive influence on his former girlfriend and her children. The defendant helped his former girlfriend's son's mother escape a dangerous domestic violence situation. Defendant fathered a child with Madeline Cologne. His relationship with her was short-lived due to his two-timing. However, after they split up, they stayed friends, and the defendant supported their child, Antonio, by regularly bringing groceries and school supplies and by paying the child's social fee for the Boys and Girls Club. Madeline had just come out of a violent domestic relationship. The defendant's calm presence assisted her in transitioning from the trauma of her prior situation. He made her and her son feel secure. The court finds these mitigators to be proven and affords them moderate weight. Considered non-statutory mitigating factor. The indirect effect of racism against Puerto Rican Americans on the defendant. The existence of racism of this nature, no doubt at some point in his life, filtered down to the defendant. However, there were no direct instances of discrimination or racist behavior directly pointed at the defendant. The court finds this to be proven and affords it very little weight. Considered related non-statutory mitigating factors. The defendant has always been a hard worker in manual labor fields such as furniture delivery and security work. The defendant has always been self-supporting, not a drain on society. There was scant evidence of the exact nature of the defendant's jobs over the years. However, the record is overall consistent with him being a hard-working, contributing member of society. The court finds these circumstances to be proven and affords them little weight. Considered non-statutory mitigating factor. The defendant escaped a high-crime, high-poverty area, independently moving to Florida when he was just 15 or 16 years old. The defendant exhibited resiliency in overcoming early life challenges. The evidence does establish these circumstances. However, there were no credible direct instances proven of the defendant personally witnessing any extreme violence such as gang violence. There was no strong evidence of the negative effects of living in a low-income environment. The court affords these mitigating factors little weight. Considered non-statutory mitigating factor. The defendant exhibited excellent courtroom behavior. Overall, the defendant was well behaved during the trial process. However, when the court received their sentencing recommendation verdict from the jury, when his conduct counted the most, the undersigned did observe the defendant expressing his disagreement to the jury. He noticeably shook his head in disapproval rather than remaining still and accepting the judgment of his peers. This came after the defendant heard the court admonish all audience members not to react by showing joy or displeasure so that jurors would not have a negative experience and be dissuaded from serving. The defendant did the very thing that he heard the court admonish the audience not to do. The court finds this factor to be proven and affords it extremely little weight. Considered non-statutory mitigating factor. The defendant will continue to offer a positive life influence on his children, other family members, and friends who have become emotionally dependent on him. Given the circumstances of his family's reaction to his conviction by distancing themselves, the degree to which the defendant's family will stay in touch with him is uncertain. However, the court does believe that if given a chance, the defendant would remain in contact with and support his relatives as best he could. The court finds this to be proven and affords it little weight. Considered non-statutory mitigating factor. After the jury recommended the death penalty for him, the defendant expressed empathy for his victims to his mitigation specialist. The court finds this to be proven and affords it very little weight. Suggested and rejected non-statutory mitigating factors. The negative effect of a prolonged appellate process on the victim's family and the dangerousness of general population as opposed to death row. The court does not find that the negative effect of a prolonged appellate process on the victim's family is a proper consideration, nor does the court find that the dangerousness of general population as opposed to death row is a proper consideration. In the defense mitigation expert report, neither of these were connected whatsoever personally to the defendant. Rather, they were framed as general policy arguments. Neither of these circumstances meet the definition of a mitigating factor under the law. That is, matters relevant to the defendant's character or record or the circumstances of the offense proffered as a basis for a sentence less than death. Conclusion after the weighing process. The court has carefully weighed the aggravating and mitigating circumstances as to each murder individually. The court's weighing process can be summarized as follows. As to Tania Wise, there are 2 aggravating factors that are entitled to very great weight. As to the unborn child, there are 3 aggravating factors that are entitled to very great weight. As to the mitigating factors, the cumulative weight of the mitigation is entitled to moderate to great weight. As to each murder, the court finds that the aggravating factors outweigh the mitigating circumstances. As required by law, this court has given great weight to the jury's recommendation. The court's weight analysis in this case, with its acknowledgement of significant yet outweighed mitigation, is a reflection of the jury's 8-4 vote for death as to each of the murders. The court's independent evaluation of the case herein leads to the conclusion that the death sentence is the appropriate and just sentence as to each victim. Therefore, Jose Soto-Escalera, I hereby sentence you to death for the first-degree murder of Tania Wise. I also independently sentence you to death for the first-degree murder of her unborn child. I hereby order that you be taken by the Sheriff of St. Lucie County to Florida State Prison for close and secure confinement until the date of your execution, at such time as scheduled by the Governor of the State of Florida at the place of execution named in his warrant of execution. You shall be put to death by the means provided by Florida law at that time, and may God have mercy on your soul. You are hereby notified that the sentence of death is subject to automatic review by the Supreme Court of Florida. The court finds you continue to be indigent and hereby appoints the office of the public defender to represent you on appeal. And that is the sentence of the court, and that will end this case. Thank you all.
All right, so that's it. Times 2. You got it for both. Not much more to be said there. Got it times 2. I don't know if they're going to have any more talking or not. Seems like that's about it. Interesting, though. Tanya's mom's not there. I don't see Elizabeth Bedolla. I don't see Elizabeth there. I'm not sure who this is either. They didn't testify during trial, so I'm not sure who that is. But Tanya's mom is not Elizabeth, right? Elizabeth Bedolla was mom's name. And none of Jose's family, all the cousins, they've all gone. Oh, Deanna, she's not in Florida? Or her son, right? Jamar, right? Wasn't that his name? Jamar, I think. I think it was Jamar. He's not there. That's Liz's sister? All right. Clearly, oh, you're welcome, Sally. All right, you guys, that's it. It ends with Jamar, yep. It ends with justice for Tanya and Josiah. So there you go. Yep, Alice. There you go. Justice for both of them. They're up north? Gotcha. All right, you guys, we have a portal if you want to come join us over at another Florida trial. Seems like we're doing a lot of Florida trials right now. But Joanne. All right, so we had a poll. Let's see let me end our poll. All right, so our poll said 69% DP, 31% life without parole. So there you have it. I never cheer for it. I mean, I agree. I mean, it is what it is. It's our system. So you don't have to be happy with it. I mean, I'm okay with, I don't know. I don't know how I feel about it. I remember when Ted Bundy was executed and people were cheering. I was just like, and I was a kid. I was just like, that's just wrong. I don't know. I don't know. I mean, I don't know. It just struck me as weird that people were cheering, you know. So anyway, that's just my feelings on it. I don't know. I'm not going to get into it. It is what it is. It's our system, and that's what we have right now. So, all right, guys, I'm going to end this stream. Thank you so much for joining us. Really appreciate you guys. Justice has been served for Tanya and Josiah. So we have a redirect on. Come join us over at another Florida trial, Daisy Link. They're winding down, and then after that, we're going to do Bianca. So we've got a full day ahead for you. So please join us. Thank you to our mods. Thank you to Aaron. I always leave you with a kitty. There's Kitty. Wait, let me see if I can get it focused. Okay, there we go. So that's little Riker. That's little firstborn Riker. And there's a couple other kitties back here. So there's a couple kitties back there. So little Riker. So, all right, you guys. Oh, and there's Houdini's above me. All right, with that, I say thank you to all of you guys for joining me. Be sure to take care of yourselves, and please join us over at Daisy Link, and thank our mods and thank Aaron on our way out. And a special big thanks to you guys for joining us through this trial. And we will see you over at Daisy Link. And with that, have a good one. We'll see you later. Bye.